15th of October this year, President William Ruto signed 8 bills into law. And of course, we mentioned the other 7, but we're focusing solely on the Privatization Bill of 2025. Karibu sana Shadrach. Just to give us an overall understanding, of the Privatization Bill. What is it about? Just the general perspective.
Well, thank you. Now we must begin from the 15th, the 15th day of October, when we lost Baba, or the news about, the passing on of Baba was shared to the rest of the world and to the country. Of course, this is a moment where all of us were thrown into mourning, and so much has been read from the acts or the actions of the president, ascending into 8 bills that were passed into law on that almost same day. There has been so much reading into the actions of the president to suggest that he did what he did in bad faith. But it is important that Kenyans understand from where they are that if we allow our political leaders to lead us, especially in understanding what the law is or what the law, as passed by the president is.
Yes.
I think we'll be doing a great disservice to ourselves, at least from the background of the understanding that our leaders have not been very honest with us.
Yes.
And this is something that we can see even in their interpretation. They know too well that Kenyans are not keen on reading on their own. They rely so much on them that even if they tell you that the president has said that all of us should be walking on water through an act of parliament that has been passed, then you are likely to believe. So my thoughts on these all issues will basically be just speaking truth to what the situation is and avoiding the politics of the day. Mine is not to support the president or to call out the opposition leaders. Mine is just to speak to the law so that Kenyans from where they are, they can be able to understand. Now, particularly speaking with regards to this Privatization Act that was passed, the Privatization Act of the year 2025, because it is no longer a bill. Now, the effect of which is that it stood to repeal the Privatization Act of the year 2005. So it means that the privatization law, or a law seeking to privatize public entities to private entities, is not new to the Kenyan law. This is something that was there in the year 2005.
Correct.
So what this law has done is to do certain improvements, if you ask me, from where I sit. Because I have had the opportunity of, reading the two of them side by side to understand the rationale. The rationale behind the Privatization Act is simple. Is basically so that if we have public companies or public entities that are running down or that are a public concern, that are a going concern, that they are not doing so very well, the understanding behind the formation of the Privatization Act in the year 2005 was so that we could help the public in saving the little that they can. I know that there is also the bad faith in which, of course, our political leaders, sometimes they do not take us seriously. So they might end up misusing the law. So that was the rationale behind coming up with the Privatization Act in the year 2005. So the law of the year 2005 had certain shortcomings, especially in view of the current constitutional dispensation. If you look at, this is 2005. We passed the constitution in the year 2010. So the year 2010, suggested so many things in terms of our change of attitude in how we want to lead the people. There was a sense in which, if you look at Article 10 of the Constitution, the proposition that the public must be involved. There is the question about public participation in everything. You've seen that is the fight that Uhuru had during his tenure. That is the fight that even the current president is dealing with. Because for a very long time, our political leaders have been ignoring the place of Kenyans when it comes to decision making. So when you look at the current, I want us to look at both laws side by side.
Correct.
So the retired Privatization Act, it had something called a commission. So this commission was responsible for coming up with a certain program. A program means that they will identify that we have this company that is a going concern. Then after identifying the company as a going concern, make the shares available for sale. Then after making the shares available for sale, of course, selling them out. That was the rationale behind that commission, the Privatization Commission. So what this law has done, the current one, it has now come up with something called a privatization authority. This is far away from the commission. You see, the retired commission was dealing directly with, coming up with a program. The sort of identifying that this company is running down, or we have these shares that are going down, we need to sell them so that we can help the government in recovering these monies. So what the authority has done, the new law, has now created or recreated the commission into an authority with a board. So the board is supposed to check the authority.
How about the commission? Did it have the board?
No, it didn't.
Okay.
So that the authority now that we have is now delinked from the process of coming up with a program. So that we have now the cabinet secretary in charge of the treasury. Is the one that is now charged with the responsibility of coming up with a program, now surrendering that program for approval to the cabinet. Then the cabinet, after looking at whether this is possible, then of course involving the people who are going to be affected by the privatization, because there are people who are working in these public companies. So their views are taken in, and then there is also the need for the public consultation. So those are some of the gains that we have gained from this Privatization Act. Because you see, if something is good or something is bad, it is from a point of comparison. So you need to compare and say this is good or this is bad from a comparison point of view. So from to that extent, then, when you have seen that we have the authority, the work of the authority is to advise the government, and after advising the government is to implement the program, the privatization program that has been developed by the cabinet secretary in charge of treasury. So they are, in a way, I mean, to be fair, in a way you see that we have some certain checks and balances that have been put in the current law. Again, I must say, I know that our political leaders, especially members of parliament, even from where I come from, I have seen, in Kajiado North, the member of parliament was trying to mislead the people. One thing that is sure is this, that the ultimate call as to whether a public entity will be sold, it is entirely reserved for the members of parliament to decide. So that once we have gone through and we have identified that this company needs to be sold, that this company is making losses, we have involved the people, the decision is again taken back to the National Assembly. That is what this law is saying. So it is the members of parliament who are ultimately going to decide whether a public entity or public shares will be sold to the members of the public. So it is not really about the government. You see, we have certain checks. So that, yes, we have reserved the decision of identifying companies that are going concern with the members of the executive. But the ultimate decision maker is who? So the person who ultimately makes the decision for us is the members of parliament.
We've seen the impeachments, and you cannot say that there is no bigger hand over the shadows of parliament.
Of course.
So tell us about that. How do we then come to terms with oversight? How do we come to terms with too much discretion in the executive? How do we balance that then?
Yes. We've been having a problem with our parliament. It doesn't mean that the architectural design of our constitution was made in error. No. The very design of our constitution to put certain offices to check others was very sound. It is actually from the Montesquieu school of thought that we see we need to have checks and balances so that someone who is given power is not corrupted, because there is always the feeling that if you give someone power, they will be corrupted. So we need to have these checks. So that when we want to, of course, acknowledge that we have had a failure in the current members of parliament, that or a majority of them who are sitting in that parliament, they have failed us as a country. It doesn't necessarily mean that the constitution is wrong. No. It only means that we as a people need to reflect very deeply about the decisions that we made. And moving forward, because you see, we have periodic elections. Correct. These periodic elections are an opportunity for Kenyans to always correct the messes that they find themselves in. So we have found ourselves in a mess. These are the people who passed the 2024 finance bill. These are the people who have passed the National Rating Act. These are the people who we trust so much with them. We give them all the comfort that is there in this country. But they do not return anything. Ni wanasema hii ni ile mbuzi wanakamua tu ng'ombe maziwa, lakini hawa wajui kupea nyasi. Hii ng'ombe wanakamuanga maziwa. So that is the problem we have with our parliament. We know that we have trust issues with them, and we know, even in view of this law, we know that they might not even be faithful. They might also be twisted by the legislature. But that does not mean that the design of the law is bad. It only means that the people who are in those offices are the ones that have allowed themselves to be corrupted by the current regime. So, Teddy, what do we do? Because we should have a system that checks itself. We would rather have the law in the way that it is, where the executive, upon making a decision whether or not to privatize a public entity or to sell shares, that decision is left for approval or disapproval by the National Assembly. We would rather have that situation, other than having a situation where the same executive that is charged with the responsibility of identifying whether we have an entity that is of going concern, deciding for itself that it should sell and for how much it will sell.
You know, Shadrach, one would ask, why not involve independent valuation in terms of auditing? Now that you're talking about that search and seeing the value of maybe perhaps selling this, offsetting this, keeping this, allowing members of the public to buy shares. And if so, if you're talking about independent valuation audits, if this can be done pending approval, how can that be enforced?
Well, the decision as to whether a company is making profit or making losses is a purely mathematical one. It's one that you look at figures. The valuation must be done. You look at, the assets that you have vis-a-vis the liabilities that you have, to come up with a conclusion that you are a going concern, that this company, is not making profit. Teddy, I must mention that a majority of the companies that have, closed down in this country have closed down because of the belief that they do not want an external investor to come and save them. A majority of even the supermarkets that we have had in this country, people believe that because we are the founding fathers of this company, then we should not invite outsiders. I mean, there is nothing wrong that if you identify that this company, Hot 96, is going down, for us to maintain the brand, you might be willing, sense will call upon you to accept assistance from someone else who is going to come in and buy some shares to assist you in running the Hot 96 company. So that is just common sense in business. I might not be a very good businessman, but I have some small logic that I am able to apply to understand that if my company is failing, I can invite someone else to come and pump in 100 or 20 million so that we keep running. They come in, if I had 100% shares, I just sell 20% shares. There is nothing wrong with that. I know the problem with us Kenyans is because we've had leaders that we cannot trust, that we think, and of course we are justified to think that way, that we've given them a window to privatize. They will go run down companies. After running down companies, make these companies available for sale, and then by use of proxies, buy these companies. Yes, but we are just in this country. If our systems are allowed to work as they should, then we will not be having this kind of problems that we always end up having. So the long and short is simple, Teddy.
Yes.
That the process of or the process that will lead to privatization of public entities is one that is subjected to valuation, is one that is subjected to a mathematical test to identify whether this company is running down, that needs it can be sustained, or there is a need to sell some of its shares. So if there is that need, the law has said this law is just prescriptive. It does not tell us that this company or this company will run down. No, it tells us that if we have this situation, then this should happen. It has given us the authority. The authority is there to advise the government. So you see, we have also delinked. We have delinked the executive also from this authority, and the authority is said to be a legal person. It can sue, it can be sued. So this authority, because it has people with knowledge of how businesses are run, it has a chair, it has even the AG is a member. So we have this authority that will advise the executive, will tell the executive that from the look of things, it doesn't make sense. Sorry, it doesn't make sense for us to pump money into this company because of X or Y. So if it doesn't make sense, then we think that it is important that we sell some of the shares of this company. Once that decision is made, it is not to be implemented by the executive. That decision is now to be implemented by someone else, the cabinet secretary, to be approved by the cabinet, as opposed to the previous or retired law, where it was the authority or the commission then that was charged with the responsibility of coming up with the program. After coming up with the privatization program, then implementing it. If this law is implemented faithfully,
as it is,
I don't think we should be having a problem with that law, because it has the necessary checks from at least the inside, and Parliament becomes the weakest link in all our fights.
David Maraga, who's now a presidential aspirant,
yes,
he criticized the Privatization Act, and he called it a threat to the country's strategic public assets, and he also urged for full transparency and public oversight. He released a statement on the 13th of this month, and he said, at the time it was still a bill, and he said that this bill bypasses constitutional requirements for public participation, and he also warned that it could concentrate wealth in the hands of a few powerful individuals while undermining public interest.
Yes, that is the retired Emeritus Chief Justice, David Kenani Maraga. He speaks as a person, with authority, having served this country as a Chief Justice. But again, he's gotten himself into the murky waters of the politics of the day. The politics of this country are purely very subjective. They are not very objective. It is to say that if Teddy is on that other side of the political divide, and I, Shadrach Wamboi, is on this other side, whatever Teddy does, regardless of how good it is, I'm never going to acknowledge it. I'm always going to look for faults. The only thing I will encourage Kenyans to do is to go and read these laws for themselves. As I mentioned when I was beginning, or we were beginning this session, I said that our politicians know too well that we are not keen on reading for ourselves, that we rely on them, we rely on the media, newspapers, for us to be informed. We do not have that curiosity or desire to dig deeper and to interact with that law and appreciate it in its full flavor. So what I'm going to encourage members of the public, because these politicians have known who we are, please, we just need to change who we are so that we are not misled. Just go, read for yourself. This law is in the public. It is, if you Google, you're going to find it.
The story of Kenya's assets belonging to the people and not boardrooms.
Yes.
And by speaking about boardrooms, we're now looking at the conflict of interest rule.
Yes.
How is it going to be enforced? Are we going to have full disclosure in terms of the beneficial owners? Are we going to have full disclosure in terms of the bidders? Are we going to have full disclosure in terms of the advisor? And how this country runs.
Teddy, we do not have a lacuna in law, or we do not have a gap in law on how to deal with cases of conflict of interest. The law has prohibited conflict of interest.
Correct.
In any event, the law is there to guard us from our excesses. We are selfish human beings. And that is why the law has spelled out procedures that are there, knowing too well that you will be probably conflicted in a certain business dealing you will want. And that is why I seek that with humility, we apply the law as it is. I mentioned that we just need to know that we have leaders who operate in bad faith, and that is the reason why we read so much. And if we are to implement the law the way it is, then I don't see when we'll be having a problem. I must also mention, these laws are 8.
Correct.
I am one person who, when I am confronted with a law that I think is unconstitutional, that it has certain shortcomings, I always run to court. Right now, out of the 8 laws, the only law that we have, gone to challenge to court is the Computer Misuse and Cybercrimes Act. That is the law. We have 2 provisions that have since been suspended by the courts. One in Kerugoya, as at yesterday, Section 6 was suspended, and another one the last week, my Lord Justice Lawrence Mugambi suspended. That is Section 22 of the Computer Misuse and Cybercrimes Act, the amendments, so to speak. So it means this law on privatization is purely procedural. And I have mentioned, I have no problem if you have a question, you point out and say that this I think, Shadrach, you have misunderstood or misread this law. But as I mentioned, from a comparative point of view, looking at the Privatization Act of 2005 and looking at this Privatization Act of 2025, without necessarily looking at the politics of, Raila died and the opposition is trying to also come up with stories, and also the government is trying also to defend itself. When you eliminate all these politics from the day, you want to do a comparative approach, you will realize that there is some certain gains that we have gained from the retired law. Because we had a law 2005.
Yes.
So we have this law has improved by bringing in consultations of the members of the public, people who are going to be affected. So to me, from where I sit, yes, I tend to disagree with the retired emeritus Chief Justice. I don't think his analysis of the issue is quite spot on, especially from a comparative point of view. But I will think that his analysis or his conclusion are basically, because you see, this is the politics, and we must be politically correct. Let me finish by saying this. For reasons that our politicians understand and know that we are not very keen at reading documents for ourselves, what they have done, they have been sharing screenshots. Because you do not want to read the whole document. People imagine that the law is...
Bits and pieces of the...
Yes. For instance, the Privatization Act is about 45 pages. So, it is also boring reading the law. Unless you have paid well. So, or if you are just, passionate about the law, you will read for yourself. So, because they know that we are not going to read documents, what they have been doing, people have been sharing screenshots. If you go and compare the screenshot that has been shared in your WhatsApp group, number one, especially in view of the Land Amendment Act, there is that one that has been going around. And another one, my friend was even writing a constitutional petition to go and challenge it. A screenshot on an amendment done on the Computer Misuse and Cybercrimes Act. Then, he even burnt the midnight oil, did not even sleep. In the morning, he's telling me that, his eyelids are heavy because he did not have enough or sufficient sleep. I asked why. That he has been researching and writing a petition to go and challenge a certain section in the Computer Misuse and Cybercrimes Act. Then I asked him to show me that section. He showed me that section. Then we opened the law, the amendment of the law. Then we established that he actually wasted his time writing a petition because that provision does not exist. So the screenshots that are being shared in the group, please, the listeners at home should be very keen. You should compare. Go and open the law. These are things that you can download and Google.
Let's look at the real issues here. When you draw back to the 90s, the issue of privatization did not start in 2005.
Yes.
Neither did it start in 2025
Yes.
with the signing of the law by President Ruto on the 15th. You look at the privatization that happened in the 90s, mid-90s. Many state assets were sold far below the true market value. And we have examples, Now, the public definitely lost ownership of the profitable or, if I may, strategically important companies. But then a small elite benefited.
Yes.
You and I know.
Yes.
So are we looking at the reincarnation of economic elites at the expense of the public? Need I say corruption, nepotism, same issues that we've been having since time immemorial? What would you pass on as your advice, as a legal expert, as a lawyer? Mm-hmm.
These are real problems that we will continue encountering. Those are some of the challenges that come with democracy. But the price that you have to pay for this democracy as a Kenyan is to be eternally very vigilant, is to call out if you realize that the law is being abused, because the law is perfect, but the only problem is the law is always being applied by imperfect people. If we have an issue with the law, as far as its constitutionality is concerned, we have courts of law. These courts of law are there to question the acts of members of parliament, to question acts of the executive. If you know of someone who is trying to take advantage and is using a proxy to take advantage of the law, because they know too well they cannot go and seek to buy these shares in their own name because of the law as it is. So they will be using proxies. It is for us to call out these people, and that is why we have whistleblowers.
Correct.
Yes.